Okay, you can start now.
All right, thanks, Ika. Hi, everybody. Good evening. My name is Samira Hassan, and I am an associate here in Thomas Phillip. If you, you're how to say you're used to the Thomas Phillip webinars, I think you would realize that the topic today is somewhat different from the topics that I normally do. But today we're going back to basics about contracts 101 and what constitute a valid contract. And we're just going to discuss some of the cases in Malaysia and and just see the elements of a valid contract. Okay, so before I start, um, this is just to give a bit of a practical view of contracts, contract law in practice. You know how if some of you who are tuning in tonight are students, for example, university students, you know how in uni we pay a lot of attention on identifying, the offer, the acceptance, the intention to be binding, the consideration, the four major elements of a contract. Well, actually, in fact, in real life, in practice, when you're faced with for example, a dispute in contract, for example, like a breach of contract or a term of contract or something, you don't actually have to go to determine which is the offer, which is the acceptance, because normally when it comes to you, it's already a signed contract. There just has been a breach, so it's a matter of interpreting the term that is purportedly breached. So that is just a bit of just wanted to let you know that, especially for those who are students or who are, who's here tonight to learn about the contract law in Malaysia. It's because when I was a student as well, I thought that, we have to identify when eventually when I become a lawyer, I have to identify, where is the offer, where's the acceptance and stuff. But when you're faced with a breach of contract dispute, it's already there. You just have to, the dispute is normally about, okay, so did the person actually breach the contract or not? I'm not saying there wouldn't be instances where you would have to identify it as an offer and acceptance. For example, if you're trying to say there are disputes where they challenge the validity of the contract, for example. But even that, we do not focus on what is the offer or what is the acceptance. It's more of like, what is the conduct of the person that has been, what is the conduct of the parties throughout the whole negotiation process, for example, or something to say that the contract is not valid or whatnot. So yeah, that's just a bit, some fun facts for you guys. That's just it's actually how it is in the real practicing world. So, okay, the basic four elements of contract in a nutshell. So you have to have your offer, that's first. And then the second one, you have to have your acceptance. The third one, you have to have the intention to be binding for the contract to be binding, or the intention to be in a contractual relationship with the other party. And of course, the last one is consideration. So now let's just briefly go through these four elements and what does it mean. So an offer, in its basic definition, is, well, an offer. When someone actually comes and say, hey, do you want to, okay, let's just take in the simplest example of an everyday life, perhaps, like buying a house. So if the salesperson comes to you, the real estate person comes to you and say, there's this lot of house, do you want to buy this house or something, that can be constituted as an offer. But do not take this like as a as it is what it is kind of thing. I'm just giving an example that an offer is whatever that a person is just saying, this thing is, well, I'm selling this thing, do you want to be in a relationship, in a legal relationship with me, wherein you will there's the transaction of of that item or a house or whatever. I'm so sorry that I'm spinning around, but I think you understand what I mean by an offer. An offer, as you know it, well, this is again back to basics. There could be a unilateral offer, or it could be like a personal offer or something. So when you say it's a unilateral offer, it's the offer like made at large. So I think that's where we go to our carbolic, the classicus of a carbolic case, smoke ball case, where it was an advertisement saying that because it was a cold medicine, and then they say that if you take that cold medicine, and if you actually recover, then you would get some sort of an award. So that was held to be a universal offer where it's to at large, to everyone who actually sees it. So we're not going to go too much into it, but just know that the element is there, that has to be an offer. So again, like I said, when it comes to the real world, for example, let's just take a breach of contract, right? A dispute in a dispute in relation to a breach of contract. So let's just take an example, because I normally do construction matters. So let's just take a construction contract, for example. So you have a developer, a house developer, who is the main contractor for a project, for a house development. And this main developer appointed a subcontractor to carry out certain works. So how when you develop a house, there's a lot of elements to it. There's the foundation building part, all the erection of the steel structures, of the cement and everything else, and then you have the people for the plumbing to settle the the plumbing matters, and then you have the electricity people, the contractors to come in and do your electricity, the roofing people, and etc. So there, sometimes it could be just like one contractor doing it, but more often than not, you actually have different contractors doing each different works. So let's just say the main developer appointed this one subcontractor to carry out the plumbing works, for example. Okay, so the offer would usually be, there would be like a tender process. So what the developer would do is that the developer would have the shortlisted candidates or shortlisted subcontractors to call them and let them put on their presentation or their tender presentation or something to show that this is our services, this is our quotation, blah blah blah. So the very fact that the main developer is calling them for for the tender process, that could be construed well. At that point, you cannot actually say it's an offer. That is a tricky situation. It's actually a dangerous slope there if you call it an offer. So if you want to be the exact point where it is an offer is where the main developer, chose, let's say out of 5 of the shortlisted subcontractors, they chose one and say, okay, hi, you're chosen for the tender. So that is an offer. So yeah, that's just an example of the offer that, I want to appoint you as the subcontractor to carry out the plumbing work. So that's the offer. Now, moving on to the acceptance. Acceptance is, of course, again, in its basic language, it means you accept whatever that has been offered to you. So in the example that I've given you, for example, the subcontractor, so obviously there would be some negotiations between the developer and also the subcontractor. They would be talking about the terms of it, for example. They would be negotiating the price. Again, in the actual practice, you would think that the price would just be there and then that's it. Well, it's actually not just like that. There would be processes where, the main developer would say, okay, we agree at this price, and then the subcontractor will say, no, what about this price, blah 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 blah. And there would always be some sort of a adjustment to the contract price. So the acceptance is finally at the end, when all the terms have been there and whatnot, then it can be called as, I finally accept whatever offer that you have given me, and that is where the acceptance is. So of course, the very basic question is whether silence amount to acceptance. Now this is something that, it was a issue during, the development time of the English law. This was like, way back then, where it was, we still use postal services. So sometimes people would deliver the offer or the contract or something through post, right? So the person who is accepting it the person who is being offered, sometimes they don't reply. So then there would be a question of whether silence amounts to acceptance. So it doesn't. So that's, I think that is again basic contract law, that they don't, silence does not amount to acceptance. In real practice, I would say that we would say that when it's silence, okay, this is where, because I remember when I was a student, I was very like a bit like kamchong about the fact that the silence, so we have to detect where is the silence, and because that, does it amount to acceptance or not. But in real life, how it works is that when, let's say, again, let's just take the subcontractor example, because that's what is on top of my head. So let's say if there is a specific provision in the contract, in the construction contract, saying that okay, before you carry out any works for the plumbing works, I need you to take out I need you to give me some sort of a bank guarantee. So a bank guarantee is just a guarantee from the bank, so that the bank will be the guarantor for the subcontractor in the event the subcontractor cannot complete the works. So normally a bank guarantee would be like a sum of money. Usually it's 5 to 10% of the contract sum, right? So okay, it's okay. Don't too worry too much about bank guarantee or whatnot. My point is, let's say there is a specific provision there to say that before you start your work, as a condition precedent, you need to provide me with that bank guarantee, for example, right? So then the subcontractor go and then accept the offer and whatnot. If, let's say, the subcontractor fails to provide, to comply with that provision, for example, well, for a very long time, and then the subcontractor went on and start the works and, blah, blah, blah. And then the developer, was fine with it. The developer accepted the works. The developer certified the payment, because you have to make payments to the subcontractor and whatnot. Because of, well, you can see there's a bit of a silence there from the part of the subcontractor. Well, not just from the subcontractor, from both the subcontractor and the developer. Why I'm saying there's a silence is because whenever a particular provision of a contract, well, not just a particular, whenever any terms of a contract is not, it is not observed by either party, the party trying to assert that right has to like immediately point out, look, you're breaching this, you're not doing this, so I have the right to either terminate this contract or, so on and so forth. So in real life, when it comes to silence, this is an example of silence. So let's say just now I said that the contractor finished the work, the subcontractor finished the work, and then the main developer actually accepted the work, even paid, for example, and stuff. So now let's say, let's say the developer didn't pay in full. They just paid like some, because in construction works, they have like stages where they will pay, right? So let's say this is the final stage where the subcon is finally asking for a full amount. And then suddenly the main contractor, the developer is like, oh, hold on. Actually, you're not entitled to this payment is because you breached one term. You didn't provide us the bank guarantee, as per X clause, for example. So in this sense, because of the developer's silence on the fact that the subcon has breached the contract, you cannot, the developer cannot like exercise its strict legal rights on that point. Now, I know this is completely like diverting from the fact of, offer and acceptance. I just wish to share this is because I just want to show an example of how silence in everyday, practicing life can be. So that is what silence, because there's no, there are instances where, people will just go remote silent and they won't say anything. But in that instance, especially now, today, a lot of people, once they are silent, they just, kind of leave it. They know that, okay, it's not valid anymore. And, there's nothing is going on, something like that. But the silence will become important when there is a contract. There has been a valid contract. There is an offer, there is an acceptance. It's just that there has been a silence on exercising the rights of parties in the contract. So I hope you kind of understand where I'm coming from of like explaining this. I don't intend to make, you know, things confusing. So I hope that is something that is helpful. So coming back to acceptance, that is it's just quite simple, as in, you know, there's an offer and then you accept it. So that's the second element. Okay, so moving on to the third element, which is the intention to create a legal relation. So basically, I think this is straightforward as well. When you want to be in a contract with someone, of course, you have to have the intention to be part or to be bound by the terms of the contract. There can be an offer and there can be an acceptance, but if, let's say, the intention is not there, and when you actually bring the matter to court, and when upon scrutinization, it is found that there is no intention to be bound by the terms whatsoever, then the contract is not valid. So let me just give you an instance. So for example, let's say if there's a seller of the car, his name is A, for example, and then there's the buyer B, right? So A offers B, okay, I want to buy this car. There's this car that I'm selling for 500K. Okay, that's too much. Okay, sorry, 50K. That must be a luxurious car. So let's just take 50K, right? So then B says, okay, I would like to accept that offer, subject to, me, let's say, for example, subject to that car being white. Okay, let's just take a very simple example of that. So then, okay, the A was like, okay, fine, it will be white and stuff. So they signed the offer and things. And then suddenly when the car came out, it turns out to be a blue car. So in this sense, what B can do is B can say that I do not intend to be bound by the terms because I specifically said that I want to be in this contract. I accept this offer if it's white, but it's not white, it's actually blue. So that's where the intention is important, because that's just one example of many scenarios of how intention can be brought up in court, for example, when there's a dispute of contract, because it is important to understand that the terms need to be expressly clear. What do I want from this contract and what do you want from this contract? Because if any of it is like not clear, this is where the problem will come when it's at the dispute stage, where both one is saying, no, I thought we agreed to this, and B was like, no, we said this, and blah, blah, blah. So that's why the intention to create legal relation is a very imperative element in a contract. However, coming back to how it is in practice, the intention, again, it's not so much on whether there was any intention or not. It's more to like a party is trying to challenge the contract, maybe on the basis because that there's this term is not precisely clear. It's a bit like vague. We call it sometimes the umbrella provision, where it kind of catches everything, right? So sometimes one party can say, I never intend to agree to a specific thing. Okay, let's just say, for example, like I said just now, an umbrella provision. Let's say a provision says that you have to have a car with 4 doors, for example, right? The car has to be a car with 4 doors, okay? And then suddenly I tried to dispute it. I said that, no, this is a breach of contract because I said I want it with 4 doors, but also want it to be white, for example. So then I rely on the provision, the umbrella provision, saying that the car has to be 4 doors, to say that it also includes, white, it has to be white or something. That is where, again, it's not actually, the court will not actually be looking at, is there an intention is there an intention by the parties to actually be bound by the terms? It's more of interpretation and whether it's reasonable for you to put such requirement or such, precondition under a vague provision. So that is basically how it is in a situation, in a dispute situation, in where it's in relation to parties' intention to create legal relation. So that's that. And then the last one is consideration. Consideration, in other words, means money, or it doesn't have to be money. This is where the cases will come in as well. Whenever there's an offer and there's an acceptance, and then there's a intention to be legally bounded by it and things like that, you have to provide some sort of consideration. So if, let's say, back to the car example, I give you the person is selling A, selling car to B, B accepted it, there is intention and whatnot, but B did not provide any sort of consideration. Let's say it has been 3 months has passed since they signed the contract, but still no money has moved from B to A, that it's completely, it can just be shattered just like that, because there's no such, there's no consideration. And also A hasn't sent the car to, so either party, there's no transaction whatsoever. It's just a mere paperwork where there's a paper that says that I want to be in a legal relationship with you, and I sign it, you sign it, and that's it, but there's no transaction, then the contract would not be valid. In English cases, again, if you have gone through, the typical contracts law textbook, in English law, they also, decided that love and affection could also be part of consideration. Now, that is something that, we need to go deeper into it. But I guess today's topic, we are just covering the essentials of a contract. So when it comes to consideration, the number one rule that you need to understand that it need not be sufficient. It must only be adequate. So what does that mean is that, sometimes how we pay deposit, right? We pay some sort of a money to book or to just show like our interest in the property, in the item, or whatever that, the thing that is in transaction. So that money or whatever payment that you made, regardless of how small it is or something, that is some form of a consideration. So if, now, of course, hold on. Before I go further than that, of course, now there's rules on deposits, on the forfeiture of deposits, on how, if let's say you pay your deposit by this time and then after that you failed to pay the amount or something after that, then the seller can forfeit your deposit, and then the seller is entitled to resell the item to anyone else or something. So that's a separate thing altogether. But let's just take it as a straight, clear case where I have paid some amount of money for that, for the car, for example. So even though, let's say the car was 50K, I only paid 5,000. Okay. So even though it's not the whole amount of 50K, but the fact that I paid the 5,000 shows that I do want to be in this contract and I am going to buy this car. So that's just the logic behind consideration being part of an essential element to make a contract valid. So that is basically the touch and go of the 4 elements of a valid contract. You have your offer, you have your acceptance, intention to be legally binded, and the consideration. So now let's just look at some authorities that has been decided in Malaysia, and there's some excerpts there as well. So the first one is in relation to, this is just an overview of a contract and how they are talking about what are the elements that needs to be in a contract. So this is the case of Sulisan Sindram Berhad and Kerajaan Malaysia in 2006 by the High Court. So if you see this side of it, okay, a simple contract requires little formality. A contract may be written, it may be partly written and partly oral, it may be wholly oral and may even be implied from the actions of the parties. The essentials of any contract are the rights, duties, and liabilities that arise from the promise or promises made by the parties. The law of contract is concerned with the mechanics involved in and the principles regulating formation, performance, continuance, and discharge of the parties' individually created obligations. So this is where, the million-dollar answer here. The essential elements of any contract are: first, offer; 2, acceptance; 3, consideration; 4, intention to be bound; 5, mutuality; 6, capacity; and 7, legality. Okay, now I know there's like 3 more addition there, 3 elements addition, additional requirements there, but the main 4 ones to form a contract is actually the first 4 ones. So that's why when I'm saying when I'm saying that in real life, it's very, very different from how we study contracts law in, in university or something. This is an example of it. Sometimes there's much more to see whether there's an offer or an acceptance, or, there's a constitution. There's so much more to it. And it is really nothing like how, because I remember in first year, whenever we prepare for examinations, we would be very focused on, oh, okay, I have to detect where's the offer and I have to detect where's the acceptance and stuff. And I'm not saying that's wrong at that material time, because, that is how the syllabus works. And that is how, I guess, we are designed to answer the questions, because they need to understand, they need to see that students understand, you can see that there's an offer, there's an acceptance, and blah, blah, blah. But in real life, it's really completely different. It's really not, it's really rare that you take the steps to, read it and see, oh, where is the offer, and things like that. Because like I said, usually when the dispute comes to you, it's already there. So what you need to now establish is things like, for example, the interpretation of the terms. So that's why, like you see there, the fifth element, like mutuality, capacity. When you say capacity, is that you need to understand, when you were entering into a contract with that one person, was that person in a, in a sound mental state of mind? Or was that person at a reasonable state of mind to be able to understand, what am I doing right now? What's the consequences if I enter into this contract and whatnot? And of course, legality, it just means that you do not, the contract does not have any sort of fraud to it, or conspiracy or something. See, again, that is where the fraud and conspiracy could also be an area where there's a breach of contract, or no, sorry, a party is disputing the validity of contract. Why? Oh, because this contract was, was entered in by the parties. It was tainted with fraud. So that's what I mean when it comes to real life cases. It's the focus is not so much on whether there's a valid contract or not. It's no, sorry, scratch that. Don't do that. What I'm saying is that it's the focus will not be so much on, oh, where's the offer, where's the acceptance, and detecting which are the elements. So sorry, I'm mumbling. So that's just something to kind of like keep in mind, that it's slightly different in real life. That don't worry, I was quite shocked as well when I first started reading. I was like, oh, maybe we have to read on the offer. I got very excited, but actually it's not that. We have to focus on other things and not where is the offer, where's the acceptance, and etc. Okay, next case, Sri Kajang Rock Products Syndrome Berhad and Maybank Finance Berhad and others. Sorry for the typo there. Okay, what it says, that to constitute a valid contract, there must be separate and definite parties there too. Those parties must be in agreement there must be a consensus ad idem. Those parties must intend to create legal relations in the sense that the promise of each side are to be enforceable simply because they are contractual promises, and the promises of each party must be supported by consideration. Okay, consensus ad idem basically is the Latin word to say that there's an intention for the both of them to actually be part of, because there's consent from both parties. The third case is the Leisure Farms Corporations Berhad and Kabushiki Kaishangu and others. So for that to be a valid contract, it does not matter whether a formal written contract has been made. It only matters that the essential elements of a valid contract has been fulfilled. Where the parties are of like mind and intend to create legal relations between the contract agreement would be valid. In this case, there was a meeting of minds between the parties. There was consideration, certainty of parties, certainty of price, and certainty of property. Although the terms and conditions of the agreement are not embodied in a formal contract, a valid and binding agreement had been concluded between the parties. The conduct of the parties shows an intention to create a legal and binding relation. Mr. Sujiki may not be fluent or understand English, but he is a shrewd businessman and the sole architect of this transaction. Kameda was present. Okay, this is including the witnesses already. Okay, blah, blah, blah. Okay, let's not get into that. But basically, uh, just to explain a bit, what it means by that, you don't have to be a formal agreement, just the fact that the elements are there, it can be a contract already. This of course applies to, for example, like an oral, an oral agreement, or it doesn't have to be an oral agreement. So for example, because nowadays, especially now, we live in an era where everybody is safe. So, even the smallest thing, that would be, someone, or, an organization or something, they would require a written promise, or a written, agreement, so that it's just safe for the future. So before this, of course, this problem would arise when it comes to oral agreements. So sometimes, before this, they would say things like, let's just take an ancestors, for example, like how maybe a grandmother promised to the first child that, uh, first grandchildren, sorry, that, okay, you know what, when I pass away, I'm going to give this house to you. So that's an oral agreement between these two people, right? But let's say when the grandmother is no longer here to certify whatever that has been said. So then we need to, establish whether there has been acceptance by the person, whether there has been consideration, and whatnot, and intention to be legally bounded and whatnot. So that is where a problem might arise, where there is no formal written agreement. So in cases like that, of course, again, the court will examine whether or not the elements have been met. And if yes, then there is a valid contract and there's no need for it to be written formally. Now, I think where this problem would arise is conduct, parties' conduct. Okay, when I say conduct, it means something like, remember again just now when I said, oh no, sorry, that one can be used because that is about breach of contract. So let's say conduct of, let's go back to the car example about, how A is trying to sell B a car, and then, but in this time, B did not really say that they want to accept it. B was just saying that, okay, I want to buy it, but I kind of need some time to think about it. Okay. And then A was like, oh, okay, cool, sure. So then what B did next, surprisingly, suddenly B paid some deposit for the car. So although there's no, the whatever agreement between the parties did not come down to a writing, or B did not expressly accepted the offer, but because B's conduct of actually paying the deposit kind of says something, right? It kind of says that I want to be in this contract. I want to buy the car. So in that instance, this is where, again, it doesn't need to be a written contract. Whatever your conduct, or even, the things that you say perhaps could be deemed as, yeah, you actually wanted to be in this contract, and therefore there is a contract and you are bound by the terms. So yeah, that's just just an explanation of this case, not this case as in the situations that can arise, that's like this case. Okay. Let's see a case on offer, specifically on offer. So this is the case of Preston Corporation, Senior Berhad, and Edward Leong and others. So an offer is an intimation of willingness by the offerer to enter into a legally binding contract. Its terms either expressly or impliedly indicate that it is to become binding on the offerer as soon as it is accepted by the offeree. Okay. Yep. So there's nothing else that I need. This is the same. So basically, there you go. That's basically the definition of an offer. So whatever conduct or whatever words that has been used by the person of making the offer, if it falls under this category, then there you go. It's a straight up an offer. So again, of course, it's important to understand that an offer, you need to make it very clear that I am making this offer because I want you to agree with this offer. And once you agree with this offer, you are bound by the terms. That is also, a very important thing of making sure that the offer is a valid offer and not, some flimsy offer that can be deemed as a, perhaps it's a universal offer. It's open to at large, so that, again, that goes back to your contract law in first year, where remember there will be advertisements, on whether or not, it's a valid offer, and etc. Okay, the next case is Hugh Jia Hao and Perdana Park City Stromberhat, and another invitation letter and booking procedures received by invited guests would neither amount to an offer capable of acceptance for the purchase of the property nor be classified as invitation to treat. Right. Okay. An invitation to treat is very different from an offer. This is where an offer and invitation to treat can be distinguished. For example, like I said just now, if there is an advertisement. So a classic example I remember my lecturer gave me is that, when you pass by the shop and then they say, come in, there's an offer for this beautiful dress, for example. That is not an offer. Well, we would say it in our daily, language. Oh my God, there's an offer. There's a 30% off. But it's not a legal offer because it's actually an invitation to treat. I remember, the way I like to remember this for my exam is that it's an invitation for me to come into the store and actually look at the item to then accept that, offer and then buy it. And there you go. That's the transaction. So basically, that is what invitation to treat is. So for example, in this case, it's an invitation letter and booking procedures. And so what they're trying to say is that it is not an offer and it's just an invitation to treat. Okay, that's that. In consequence, the statements contained in both documents, in my view, will not qualify to even say that there was in the instant case a unilateral contract as advocated in cases like Carlyle. In Carlyle cases statements. Okay, sorry, this is just talking about the universal office, right? So. Yes, sorry, just need to kind of like process the things in my head. So yes, what it's basically saying here is distinguishing distinguishing the case in this, which is it's an invitation letter, and then the case in the Carlyle, where the Carlyle was accepted as it was a universal offer. Universal, yes, okay, all right. Acceptance, the case of Charles Grenier, Numberhart, and Lau Wing Hong. So, and what it says is that an agreement to enter into a contract is not a binding contract. Whether a contract can be said to be binding or valid depends on the fact of the matter. The court has to construe the correspondence of the parties to determine whether there was a binding or valid contract. An agreement to make an agreement that does result in a contract. It is for the court in each case to construe the correspondence exchange between the parties and to say whether that it is the result intended by the parties. Okay, so again, this comes back to what I kept on saying about how it's very different in real life. Because again, when you're answering an exam question, you would think that okay, there's an offer and an exam acceptance. There you go. It's a valid binding. Yes, in theory, of course. In exam questions, please do not write differently. I'm just trying to distinguish the theory part and also in real life, because in real life doesn't mean that if I signed a contract, for example, let me just give an example of a case where I've dealt with. This is an arbitration matter. So for an arbitration matter, there would be a clause to say that the arbitration, in the event that there's any challenges arising from this contract, or even about the validity of the contract, parties need to refer to arbitration. So in the arbitration, the party was because we were the respondents in the arbitration, and so the claimant was saying that you have breached the contract. So we are saying that, look here, we did not, there's not even a valid offer. We did go for your negotiations, we did go in for meetings and whatnot, but there's no, because we did not meet the requirements in the contract to be deemed as, yes, we're already, there's a contract and we're together in this. But that's the thing. If theoretically speaking, you would see that because we have done this, and we have there was even a signature in. It's not the contract itself, but it's called the terms. This will get deeper into it. But let's just say it's the pre-contract stage where we actually said, okay, this is what we want to do, blah 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 blah. So if we take it straight from the textbook, it would mean that there's an acceptance and there's a valid contract. But again, like this court has perfectly described it, it's not like that. You have to see the factual circumstances. Is there any other conduct after the pre-contract, for example, that that has, is showing that no, I actually do not even intend to be in this contract, or etc. So yeah, I think that is just something to be kept in mind. But of course, it does not divert from the fact that an acceptance is part of an essential element of a contract to make the contract valid. Okay, and this is just a case in English Authority, Brockton and Metropolitan Railway Co. Acceptance may be conveyed by words or conduct. Acceptance can be established from the conduct of the promisee, where the acceptor acts upon the terms of the proposal that constitute an acceptance. So again, it could be by words, it could be by conduct, like my example about, paying the deposit. By the very fact that I paid the deposit, although before that I actually said that, oh, let me just think about it first, but the very fact that I actually paid the deposit kind of means that I kind of accepted the offer. Okay, the case for intention to be binding. There's a case of Loh, Karyit and others, and Muhammad Isa and another. So what this case says that where the parties only intend to bind themselves through a subsequent contract, and when they enter into that formal contract, then no contract exists until the formal contract is signed. Okay, in other words, what this case is trying to say is that okay, let me just read this because I think this will explain it even better. So the defendant had given the plaintiff an option to purchase a land. On a piece of paper, the term was subject to a formal contract being drawn up and agreed to all parties. So when you see that term, subject to a formal contract being drawn up and agreed to all by parties. So in that, it is very, very clear that if the intention of the parties was that, okay, we will be in a contract once there is a formal contract between us. So whatever that has been going on now, whatever negotiations that we have been doing, whatever, it will not be construed as a contract, because a contract will only be there once there is a formal contract. So I think this is what I've touched as well earlier on when I said that the intention to be binding is where, it has been expressly, set out there that I only want to be part of this contract if this is met, if you do this, for example. So this case, it's a classic example of what is the intention to be binding. It doesn't mean that just because there's an offer, I'm saying, okay, yes, definitely. I might have said that, no, I am okay with this offer, but it's just that there has to be subject to these terms. So that's what the intention to be binding is. There's also a case of Cipta Cermat Sdn Bhd and Perbandaran Kemajuan Negeri Kedah. It was found that there was a valid contract despite the want of a duly executed formal agreement. This was because all the other elements of a contract had been fulfilled. So even if there is no formal agreement, based on the conduct of the parties, the contract is able to find that there is a valid contract. I think this is, all the cases are somewhat like a repetitive thing, which is that in a contract, it does not mean that you have to specifically have a formal contract in the sense that it has to be written, it has to be, signed by both parties immediately or something. By just the very conduct of it, it means that you can actually, construe it as a binding contract by itself. So that's why it's very important to just kind of put that in mind about the fact that there could still be a valid contract even though there's no formal agreement and whatnot. So that's that. And this is a Court of Appeal case, so that gives it even a heavier weight on it. All right, next is the consideration. So again, on the consideration part, it's where I said that there has to be some sort of a transaction between the parties. It could be money, or it could be the transaction of my example of the car, for example. If the seller actually gave me the car, so there has to be some sort of a transaction of the item there. So in the case of Pang Sui Kim and Beh Ai Hock, it says that as long as there is some sort of consideration, the inadequacy is immaterial. Merely inadequacy of consideration is insufficient to set aside the contract unless the inadequacy was too great that it amounted to fraud or duress. Remember when I said that, it doesn't have to be sufficient, it has to be adequate. So for example, if the car is 50,000 ringgit and I just paid 5,000, so even though it's not exactly the purchase price of the car, but the very fact that I actually paid some money and I actually did, give you some sort of a there's a transaction between you and me, that amounts to consideration. So yeah, but again, when it comes to, dispute, I mean, maybe this is different for me because the contract that I've been exposed to are mainly construction contracts, for example. So usually there has been some sort of consideration. There's been some transaction. So I always need to establish other things when it comes to the construction contract. Okay, sorry. All right, coming back. So again, consensus ad idem. This is just in a case. Well, it's actually similar to intention to be in a legal relation, but let's just see what this case says. It's the case of well, I am not good in German, but it's Bank something, Malaysia Berhad, and MBF Holdings Berhad and another. So this is a federal court case. So what it says that without consensus ad idem, there is no concluded contract. It is itself insufficient to form a concluded contract. There must be intention to create legal relations and consideration. Let's just go deeper into the discussion. There was no deliberation of the intention to create legal relation. To be fair, the trial court needed not, since it was its finding that there was no consensus ad idem on terms to deliberate on the intention to create legal relations. But there was no reason for the Court of Appeal not to proceed to deliberate on the intention to create legal relations, since it was finding that there was consensus ad idem on the terms. The intention to be bound is a jural act separate and distinct from the terms of a bargain. To conclude that there was a concluded contract merely on account of a finding of consensus ad idem on the terms, there was serious misdirection by the Court of Appeal, as said the presumption of intention to create legal relations could be negative. So yeah, that's basically that. It's I hope that is a bit clear. I know it looks a bit different because this is from a PDF. It's because I just wanted to show the cases. So I believe I have a question. Let me just read it out. This is a question from HK Chan. He said that didn't get the early part about silence. What happens to the case when developers stay silent about bank guarantee? Okay. This is a very tricky question for me to answer, because I think I need to understand the factual matrix of the relationship between the developer and also the bank, as in what is this contract about? So, well, sorry, if you're saying it is a developer, so I'm assuming it's a let's say it's a sham purchase agreement or some sort of like that, right? So when you say silent about bank guarantee as well, that also, this is tricky because I need to understand what do you mean by silent. Is it not contained in the agreement, or is it not spoken to during the negotiation part or something? Because let's say it's the where it's not expressed in the contract, then it means it's not a term under the contract, and because of that, then you don't actually have to discharge that duty under the contract, because there's no such term in the contract. But let's say it's in the negotiation stage, or in the process where you are talking to the bank, understanding talking to the developer, understanding more of the the transaction and whatnot, and they did not say anything about the bank guarantee. Well, this is where it really depends on the final agreement, the draft agreement between parties, as in how exactly parties are to come to terms with the bank guarantee, for example. So I'm afraid I can't really give you a specific answer to this question, because I kind of need a bit of a context as to what is silent. Because remember, like I said, for example, if there is a term requiring you for you to get a bank guarantee before you okay, let's just go back to my example just now about the developer and also the subcontractor, right? So let's say that there is a precondition term under the contract saying that before you start work, before you start the plumbing work in the project, in the house project, I need you to get a bank guarantee. Then only you can start work, right? Okay, so there is the term. And so me as the contractor, I go and do my work, but I did not get the bank guarantee, right? So throughout this whole time that I'm doing work, and even up to the completion stage, the developer didn't say anything on their part. But you have to bear in mind that there has been a contract. This example that I'm giving, there has been a contract, and there is a term stating that you need to give a bank guarantee. Okay, so coming back, so the developer is just like, keeping quiet about it, and developers like, okay, fine and dandy, even like, certifying your works and make some progress payments for whatever works that you have done. And then finally, when the contract is coming to an end, you have completed your works, you're just requesting for the final payment for the final account. Suddenly the developer is like, oh, hold on, actually you're not entitled to this money because like you didn't even get the bank guarantee. So this is where the question of whether or not the developer is entitled to enforce the strict legal right of that particular term, of the term that I, as a subcontractor, need to get bank guarantee. Why? Is because the fact that they were silent for the very long time, in fact, until I completed the work, it amounts to a waiver on their part. When I say a waiver basically means that I kind of already, by my conduct, I let go of my entitlement to enforce my strict legal rights under the contract against you. So on that basis, then if the developer is silent, then that term is still alive. And not that term is still alive. The term kind of like is it's all right on my part not to observe that term is because you were silent, and so now you cannot come back. I've done the work, I've benefited you, I've discharged my duties under the contract, well, except for the bank guarantee because now we're in trouble. But because I did that and you were quiet, you had ample time to do this and whatnot, but you still did not do it. So you now cannot come back and say that you want to enforce your legal rights. But even on that part, it does not come back to the question of whether there was an acceptance or whatnot. It's actually a question of whether there was a breach of contract. Because like I said, in that situation, there has been an agreement, there has been a contract. So yes, HK Chan, if you're still here, I mean, if you would like to provide me with further context of your question and whatnot, please do. My email is smh@thomasphilip.com.my. So I think that would be better. So yeah, I guess that's about it. I hope that has been helpful. Wow, I've spoken more than I should have. So I hope everyone is found it helpful. And yeah, thank you very much for tuning in tonight, guys. I hope to see you guys next time. So take care and stay safe, everyone. Bye-bye. Oopsie, stop share.